everyone. I'm Esther Cohen, and I'm the director of High Care, which is a program available through our Jewish Community Foundation of the Jewish Federation of Broward County. It gives me great pleasure to have one of our legacy donors, Mrs. Ava Phillips. Ava Phillips and her late husband, Dr. Jim Phillips, was very involved in the Jewish Federation here in Broward County.
When we moved here and we started getting involved, we didn't know anything really about philanthropic. We knew about giving to the Jewish Federation. We knew my husband became president of SORF JCC. He also was president of David Posnack Hebrew Day School, which became Jewish Day School, and I was president of Central Agency for Jewish Education. So we really started getting a great education. We really got very involved. And I started hearing about High Care off and on and didn't think much of it, but we decided to become legacy donors. As I became more involved in that part of our lives, my husband started getting sick. And it was over a period of about 7-8 years. It was a progressive disease, it was diabetes, it was kidney failure. It was very difficult. Through it all, my husband continued to work as a physician. He was a very successful physician. First he was an emergency room physician, then a family physician, and then finally pain management doctor and medical marijuana. As he was getting sicker and sicker, for some reason, Michael Belabin first reached out to me and wanted to know how he was doing, because people started hearing that Dr. Phillips was really getting sick and he wasn't showing himself anymore in the community that much, and people really wanted. Michael Belabin was very sweet. And then came Esther Cohen, and she said, you know, as part of this legacy giving, you're entitled to some High Care stuff. I'm using the term stuff because there was so much information. It was a lot of stuff. And she really walked me through it. Not only did Esther walk me through it, she held my hand until my husband passed away 7.5 months ago. Through it all, and she owes me banana bread because she was making me banana cake and banana bread all through the time. She was visiting me every Friday before Shabbos. My husband was alive, and then he wasn't alive anymore. She came even during the pandemic on my driveway because, of course, he died in October, which was the height of the pandemic, and it was very difficult for people to visit. So if people did visit, it was always on the driveway wearing masks. And we're still very good friends today, and she's still visiting me on Friday, but it's been quite a ride, and High Care is probably one of the more important aspects of the philanthropic endeavor because it's really where you need people the most. You're the most vulnerable. That's when you need people.
Thank you, Ava. I have no plans to going anywhere, and I will make you the banana bread. Thank you so much for sharing this heartfelt message. You know, High Care is a wonderful program when people really need it the most. It's an individualized program targeted for the needs of a person, and that is a value-added benefit when you become philanthropic and you become a legacy donor. We do anything and everything other than making financial and health decisions.
Well, even health decisions, though, Esther, you did give up some names. When I needed some care at home for him, you actually were very helpful because I really didn't know who to go to, what to do. I just knew he needed help, and I needed help because I couldn't handle it by myself. And you were actually very instrumental in helping me out.
Well, Ava, it's been a wonderful privilege and honor that you allowed me and your late husband to assist, help in any which way possible, to provide resources, because High Care not only helps those for patient care needs, but also for resources, other avenues, if and when something does happen, because it's very challenging to navigate the healthcare system when one's facing aging issues and problems. So, you know, I feel very honored to have helped you. I look forward to helping, being there for you and others that are legacy donors.
Till 120, as we say.
Yes, amen. Thank you.
Hello, everyone. My name is Carol Lasik, and I'm the outgoing chair for High Care. Welcome, Ms. Becky Tinter, our new incoming chair. As you all know, High Care is a concierge care management program of the Jewish Federation of Broward County, and it's my privilege and honor to introduce our speaker, Kevin Milgram, a CFP, on our webinar series. Before I do, though, I'd like to thank the High Care program. First, for allowing me the opportunity to showcase all the wonderful things that High Care does for our seniors and aging with dignity, and also for allowing me to find my voice. As chair, I was tasked with the writing of a few words of wisdom every quarter for our newsletter, and my team will attest to the fact that it wasn't an easy task, but what I learned from this experience was invaluable. It is very important that we all learn, as Jews, we all learn to find our voices. With anti-Semitism on the rise throughout the world, and as recently as our own backyard, Miami, with Israel's very existence being threatened, and with our own college kids being attacked on campus, we all have to learn to speak up. Do not be silent. I watched a Zoom graduation last night, 8th grade, for my granddaughter at Teaneck at Yavner. And it was so uplifting to hear these young teenage voices, their dreams and their goals for the future. We have to speak up and protect their future. Do not be silent. Let all of our voices be heard. Kevin Milgram. He's a certified financial planner, director of financial planning for BNFL Lasik and Star. Kevin has over 20 years of experience of helping families with their financial needs and goals. I'm going to read Kevin's bio here. Kevin describes financial planning as a combination of art and science, an apt analogy for a visual arts major who took an economics class and never looked back. He discovered his love of finance at Florida International University, where he met his first mentor at a Hillel organized career night. Right then, he decided he would become a financial planner, and after graduating with a degree in finance and business, and over a decade later, he joined BLS Wealth Management. Over a decade later, Kevin continues to help clients as a certified financial planner. He's a practitioner with a special focus on retirement planning, and he describes his role as being the point person for a lot of clients. Because he oversees putting together the client's financial plan, Kevin is actively involved with every aspect of a client's strategy. I like seeing the whole picture, he says. I like staying current by constantly reading. Our work is never done. His topic will be financial planning, charitable giving, estate planning, and techniques to help protect yourself and your family. Please help me welcome Kevin Milgram.
Good morning. Thank you for the opportunity to talk to you guys this morning. I'm hoping this presentation will help you guys and everyone watching open up a couple conversations with your current board of directors, maybe your current advisors, your family. The topic this morning will be the 5 estate planning documents you should know. And at the end, the plan is to give you some charitable giving techniques that are seldom used, but are a little creative in nature to hopefully give you each and every one of you additional tax deduction, and also to give you a little more of a conversation to have with people at the charities and as well as your advisors. So that I'm going to share my screen. One quick second. Okay, wonderful. So no presentation will be complete without disclosures in the beginning. At BLS Financial, we're not CPAs or attorneys or financial planners. And the idea here is to kind of create a conversation so you guys can take back some ideas and talk to people in your professional life and personal life, and use these as a stepping stone to create additional conversations. So this morning, what we'll be talking about is what is an estate plan, some important documents, and how life insurance and estate planning may make sense in everyone's plan. So what is estate planning? Estate planning is the process of transferring assets of your estate while you're living and at your passing. It's designed to protect your assets when you pass away and God forbid you become incapacitated. It determines who, what, and where will get certain things. It creates trust in the terms of for minors and adults who might need additional assistance. Minimizes estate taxes if they come into play into your planning. They certainly reduce expenses and avoid delays. If you pass away or become incapacitated without any documents and the courts get involved, or there are people who can't decide on what is the best thing to do, obviously it adds time and expense. Provides liquidity if there's an estate tax need. And what I think is the most important is control. If you guys don't decide what you'd like for yourselves, someone else will decide for you, either a family member or, God forbid, the courts. The first document we're going to talk about this morning is a healthcare proxy. And speaking for high care, this becomes really, really important. They become liaisons and assist people with making the best decisions possible for those who can't make them for themselves. A healthcare proxy, at its basic level, is you designating somebody to make those decisions if you can't make them for yourself. These healthcare proxies come into play when you are sick and unable to communicate what you want your needs to be. One of the most prevalent cases in the last several years, or many years ago, was the Terry Chavo case. If everyone's old enough to know, recall, Terry Chavo was a woman, I believe in Tampa, Florida, who became comatose, vegetative state. And unfortunately, her husband and her family were at odds on what they wanted to happen to her. And because of that, it ensued an entire several-year court case, and a very public one at that. If she'd had a healthcare proxy to designate exactly who would make those decisions, then that court case would never happened. That's an extreme case. Healthcare proxies come into play in everyday life also. With high care and elderly and taking care of yourself, designating somebody who will make those choices for you is very important, especially as we age. Additionally, if you have young kids who are going to college, once they're 18, it can be very difficult if something happens away at school. We had an associate here whose daughter was at Gainesville, University of Florida, who had an event and unfortunately was in a coma for a few weeks. If he wasn't carrying that healthcare proxy with him everywhere he went, no one was talking to him, and she was 19 years old. So it's exceptionally important to have these documents in place. When kids are minors, it's less important because you're the parent, but once they become old enough, or at 18 or get too old, it's a very important document to have in your estate plan, either for yourself or your loved ones. What happens if you don't have one? Kind of discussed this a little bit already. If you're under 18, really it goes to your parents, legal guardians. If you're over 18, they usually go to the next of kin, a spouse, a sibling, adult kids. But if there is a discussion or squabbling, and similar to Terry Chavo, the courts can get involved. And if you don't have certain things in place, you may not have access to important medical information, make decisions, or know what's going on. Who do you name as a healthcare proxy? Proximity is a big deal. If you have a sibling in California, New York, you may not want to name them as a healthcare proxy. You want someone who can show up at the hospital someplace nearby, who can attend to you and assist. Somebody who has the ability to make clear decisions and understand the healthcare system. In the intro, I think Esther discussed that with the donor she mentioned there. It is a big web. It's very difficult to navigate. And having someone who knows the system, someone who can be on your side and advocate for you, whether it's someone at high care or someone personally, is exceptionally important. Age and health is also very important. If your spouse is too old or someone you're going to choose, either they're too young or isn't healthy, it can be a challenge for them to act in that way. If you already have a document, congratulations, it's wonderful, but make sure it's dated. Make sure it's signed and dated. You have copies and you've actually spoken to the people who will be filling that role. Make sure the person's contact information is up to date on that document. Make sure you've spoken to the person and they can accept those kinds of roles and that responsibility. It's always important in all these documents to have at least one or two, if not three people in line in case one person is unable to do the job or is unwilling to. And every state has their own requirements, so make sure you talk to your attorney. A very common question is healthcare proxy the same as living will? The short answer is no. Living wills are both of them actually advanced directives. They're both giving directions to a future potential possibility. A living will states certain medical treatments you don't want to be given. The most basic or extreme would be a DNR, do not resuscitate. But there are a slew of things that people may not want to receive medical care. A healthcare proxy is someone you designate to determine what track to go on for medical care if you can't make it for yourself. So they're very different documents. Very commonly, they're in the same document if you have certain cares or certain concerns about what you'll be receiving or not, but other times they're separate. So it's important to discuss both options with your attorney. The next document we're discussing is power of attorney. We just discussed medical care. Now we're going to talk the finances. God forbid you're incapacitated and unable to make decisions, they'll need access to accounts, assets, monies, whatever it may be. A power of attorney does that in the case of incapacity. The one we're talking about now is called durable. The durable power only comes into play when someone is incapacitated. There are other ones in general can start from day one, but for this purposes, we're talking about durable, and they really only come into play and give that person power if you can't make those decisions for yourself. The document can take effect immediately, or it can begin incapacity. Again, this is durable we're talking about, so it becomes incapacitated. How they define incapacity is up to you in the document. In that document, you may require a couple of doctors or one doctor, so you review it to make sure it is to how you'd like to have it be initiated, but really is define whatever's in words there, and you can consult with your physician, you can consult with your attorney as well. When making a power of attorney, what should you think about? Same thing as a medical surrogate. You want to make sure you have backups. If someone is unwilling or unable to perform that duty, you want someone else who can step in line. On the medical surrogate, as well as the power of attorney, generally it's the spouse who's the first person, maybe an adult child, maybe a friend. But you really want a couple of people to be in place to take care of those things. Contact info is very important. Being able to contact a person, up-to-date telephone numbers and whatnot. Digital assets is a big deal. You want the person to be able to have access to things online. I know it's kind of no-no in terms of technology, but you're not really supposed to keep a password list, but there are password keepers and things, and you want to have people be able to get access to Facebook, Instagram, those kinds of accounts, in addition to all normal bank accounts and the business accounts. Business language is important. Sometimes people have separate powers of attorney just for businesses because they don't commingle. So it's important to discuss those if you do have a business. And the last one is make sure it's signed and dated. And it has to be recent. And some courts won't uphold power of attorneys or medical surrogates if they are too old. So it's important to really review these documents every 3 to 5 years if possible and make sure they're up to date with people and the dates signed correctly. The next document's a will. We call will a wish list. It really is just an expression of your wishes, what you'd like to see happen. Wills also come into play when you have minor children, designating a guardian, someone to watch over your kids if you can't do it yourself or no longer there. Sometimes wills create trusts when someone passes away, and wills can be ranged from something very simple to something very complex depending on your needs. It's important to understand that a will does not bypass probate. If you have a testamentary trust, a trust that's created under the will, it could still require a court in order to make it initiate that. So wills in themselves are just wish list things you'd like to do in their guidelines. I joke all the time, you never see a movie contest a trust, but they contest wills all the time. So they're not foolproof. It's important to understand how they play and why they work in terms of your planning. What to look for. Similar to power of attorney and digital assets, you want your executor, you want whoever's going to be in charge of your estate if you should pass away, to have access and language in there that allows them to turn off social media, have access to different accounts. This is language that's only become prevalent in the last 5 or 10 years. So it's important to review your documents to make sure they're in there. Date and sign is another one. If you have a copy or a draft, it's not going to do any good. No ex-spouses or others that don't belong. Many wills actually have language that will state, if I get divorced, such and such will happen. That's wonderful language. But if it doesn't, you've been divorced, there's been a change, you certainly want to make those adjustments. The executor is a big job. Make sure you communicate with the executor that you're asking them to do a job if they need to fill that need. I had a client a couple years back. I went to review his documents, and lo and behold, I was the executor after his wife. He never spoke to me about it, never mentioned to me. I asked him, is this what you really want? He's a good friend, and it's actually my family, so I had no problem doing it, but he never told me. And if I wasn't reviewing his documents just because it's my job, then I would have never known. And that conversation never would have happened. So it's important to communicate all of these jobs to the people you're asking to do so, to make sure they're willing and capable of doing so. So what happens if you don't have a will? The short answer is you do. It's called the state of Florida. Florida will designate what happens to your assets when you pass if you don't designate themselves. Generally, they'll give it to your spouse, your kids, they'll split it up, but every state's different. But if you don't decide what's going to be and what's going to transfer to whom, someone else will do it for you. In the special case, you're talking about young children when guardians, the same thing happens. They usually wait for someone to step up and take the responsibility. But if someone doesn't, then they'll appoint somebody if necessary. So talking to that person you appointed as a guardian for young children, for minors, is also very important. But the state will decide if you don't do it for yourself. Probate, mentioned this a couple times. Probate is the court process to distribute your assets at your passing. There's some pluses and minuses to it. Most attorneys work really hard to avoid the probate process because of its disadvantages, which are it takes lots of time, it's expensive, they actually charge your estate, and it's also public. Anything going through the court case is public record and someone can search for it. There are some advantages though. You can understand though, the probate, what they're really doing is they're opening up your estate and giving the ability for people that you may owe money to come and claim against the estate. So if there's creditors, loans, whatever it may be out there, they can actually make a claim and the court will determine if it should get paid out or not. So in that sense, a probate is once opened and it's closed and it's very hard to reopen again. So creditors can't come out of the woodwork in the future. In the case where you have minors or there is a problem with the executor, the courts will supervise that process. So it is nice to have someone looking over someone's shoulder. But if you've gone through the process of actually putting these things together, then it's really, you don't need these things, especially if you communicated properly with individuals, you have attorneys, you have people who know what's going on and what you want to see happen. This can all be avoided, especially because of the public nature of it. There are assets that pass outside of probate. Again, you don't want to, and there's things you can actually do. The first thing is joint accounts. Normally it goes to the other individual or there may be a beneficiary that's named there. Assets that always have beneficiaries are life insurance policies, annuities, and retirement plans. You never want to leave these to the estate of the insured or the estate of the individual because then that money goes into the probate process. Whenever you can name a beneficiary on a document, it bypasses all of those things and even bypasses creditors. So one of the things I like to take away from today is at the very least, review all the beneficiaries of all of your accounts and make sure they're going to the right place. And if you need to make adjustments, you can. If you have an account that doesn't have a beneficiary, you can ask the institution if it's not possible to add one, which is also a big deal. Some bank accounts allow it, brokerage accounts, and so forth. Another asset that passes outside of probate is actually revocable living trusts. What is a revocable trust? The name says it all. It's a trust that I can create and I can change it whenever I want. When I pass away, it becomes law, it becomes irrevocable. But while I'm living, I'm in complete control of it. It's basically a fancy name for me. But what it does though is avoids probate. It puts things into law. It ensures privacy. No one can tap into it. No one knows what's going on except for the trustee and the beneficiaries and the attorney. You name a trustee at your passing, and they can manage the money and take care of things. God forbid you're incapacitated or pass away. But there are no delays. It happens immediately. Once someone can sign some papers that accept responsibility, you're good to go. These are also much more difficult to challenge than a will. The joke I made earlier, you never see in a movie that someone's contesting a trust. It doesn't happen. Normally it's just a will. So the trust in and of itself adds lots of layers of protection. And also you can dictate things after your passing. So if you have minor children or you have kids or family, you don't want to have access to the principle of the trust, you can create some bumpers or some guidelines. Very common ones are, during their life, they'll receive interest and dividends to support them in their health and their education. But they'll have access to a third of the assets, or the principal, at 25, another 30, a third at 35. You can put protections in there for the assets and for the beneficiaries. It's really up to you. What should you think about? When a revocable trust is first created, you're actually the trustee, and normally you have your spouse as a successor trustee. In the event that both of you pass away, you want to have successors there and people that you know will have a good relationship with the beneficiaries. People that you know will have the ability to make decisions, financial, and be able to have a conversation. So normally you want a couple of them, no different than other documents. You want 1 or 2 or 3 successors. Times you might want to review your trust. Your net worth changes, beneficiaries change, kids get married. One of the things that we see a lot of, I can't tell you how many times I've seen this happen. A client will walk in with their documents. They'll say they have an estate plan, they have a trust, just hand it to me. And they think they're all set. But when I start to ask, what beneficiaries did you change to make the trust be funded at your passing? What assets did you put in the name of the trust? The answer is we didn't do anything. So really all they have is a really expensive stack of paper. What are the things you do after you create the trust and your estate plan? There are things you need to do in terms of putting assets into the trust or changing beneficiaries to fund these things. Otherwise, they don't come alive. If assets aren't inside of them or they aren't funded, nothing will happen at that time. Another kind of trust, which is kind of really coming back to light a little bit with the potential changes in the Biden administration with the estate tax. An irrevocable life insurance trust is just that. It's a trust that you create that can't be changed. And normally it's designed just to hold life insurance for the purposes of paying estate tax. When you create an irrevocable trust or a trust that really can't have access to, it's important not to put certain assets in there if you want access to them. So life insurance ends up being one of the perfect tools to do so, because at your passing, it'll create liquidity to pay estate taxes. Right now, as it stands, any individual can pass $11.58 million without estate tax, and a married couple can pass right around double that. Biden, if certain tax changes come to light, would reduce that to anywhere from 3 to 5 is the estimate. No one really knows for sure. But that's a big difference between being able to pass $23 million or 6 to 10. So if anyone has $10 million or more of assets and net worth and is concerned about estate tax, you need to go back to your attorney, review your documents, and see if an irrevocable life insurance trust or an ILIT makes sense. There are provisions you can put into the trust that allow spouses to get access, but it really depends on your planning and what you want to accomplish. But these trusts are becoming more prevalent as we're looking at certain changes coming down towards the end of the year. A little more information on ILITs. Really talk to an attorney. If you have a net worth higher than that, it's important, but also important, the same thing as trustees and how things are being paid out. Make sure it fits your needs. When should you review documents? So anytime there's a divorce, a marriage, a child's born, a death of a spouse, anytime there's any kind of life event, you want to make sure you review your documents. Law changes, we just discussed now, towards the end of the year, everyone here should be reviewing the law changes. There isn't just estate tax changes, there's also capital gains changes that may end up affecting people. And also old documents. You really want to start reviewing them at least every 3 to 5 years. At least have a conversation with your attorney at that time. As a recap, some of the documents we spoke about: healthcare proxies, power of attorney, the will, revocable trust, irrevocable trust. These are all documents that are really just the basis of any good financial plan. Any good attorney will be able to draft these for you and make sure they cater to what you specifically are looking to accomplish. But really it starts with the conversation with you guys and what you want to accomplish for your family. There is no one fits all situation in financial planning or estate planning. It's important to have a real frank conversation about what you'd like to see for your family and for yourselves. And in doing so, an attorney can put all these together. All right. The next thing I want to talk about quickly is charitable giving. I wanted to give a couple of ideas that are seldomly used, but I know that the Federation and High Care have possibilities to affect these. Once again, we're not attorneys or CPAs, so it's important any ideas we give this morning that you talk and get some tax guidance, make sure they fit you. These are some ideas or some things that we've had clients really get some benefit from with us working with their CPAs and attorneys. So please obtain tax guidance, understand the legal matters of these things. If you need a document being drafted, talk to an attorney, and make sure that you are expressing exactly what you're looking to accomplish before doing anything really, because that way a good professional can really help and assist you and effectuating those changes, making those things actually happen. So a lot of our time is spent having conversations with people about what they'd like to accomplish and then giving solutions to make that happen. So the first thing is, these are the basic gifting strategies. Everyone's written a check to charity, God willing, and hopefully you'll write more, right? So a cash gift is very easy. You write a check. But in today's environment, certainly with the stock market being what it's done over the last year, coming out of the ashes of COVID-19, you have the ability to give away what's called appreciated assets or stocks. Let me give you an example. We have a client who's very well-to-do who wanted to give $100,000 to a school as a charitable gift. And she was prepared just to write a check. We had a conversation with her. For her planning, we were looking to reallocate her investments anyhow and sell off some securities. And in doing that, we would have incurred a capital gains tax. For those who don't know, a capital gain is anytime you sell a stock or anything and make money off of it. Within a year, you get taxed your income tax bracket. Past year, you get taxed long-term capital gains. And those long-term capital gains can be anywhere from 15 to 20%. And if you're selling it within a year, it could be your tax bracket. So in this situation, she had $100,000, reallocating her portfolio, as opposed to selling these stocks out and just giving her the money to pay it. We actually gifted the stocks to the school. And in doing that, two things happened. The first thing is she gets a deduction for $100,000, the same she would normally. The second thing is she didn't have to sell anything to incur the tax. So she gets the deduction, the school gets their money, and she received an additional $15,000 to $20,000 in taxes in doing that. The same can be done with real estate, other assets as well. So I encourage you, when you start looking at gifting, talk to certain charities and see if they'll accept stock if you have it. Go back to your financial advisor, your brokerage account, see if there's certain securities that you have that are appreciated, and you have some extra gifting there. There are some guidelines. Talk to your CPA. Normally, these kinds of gifts cannot exceed more than 30% of your adjusted gross income. So be aware of those things when doing that. But if it's an idea that can generate more income for charities and save you some tax dollars, that'd be wonderful. The next thing is life insurance. The Foundation and Federation and HICARE have programs that allow people to buy life insurance and gift policies to the charity. What I'm talking about here in this slide is really getting a policy and making the charity actually the beneficiary, which is pretty common. If you have a policy, you don't need any longer. Another option is to actually make a gift to the charity and the charity buys life insurance for you. This can be done in two ways. Either the charity will end up buying a policy for you, but if you look in your planning and you have older policies that you no longer want or need or are thinking of surrendering or getting rid of, because you no longer need them for your planning, and please consult your planners and your CPAs and attorneys before you do that, you can give that life insurance policy to a charity. And the value of that policy would be a deduction for you. And you can make cash gifts to the charity, and they can then keep that policy for you and pay the premiums. So before you make any kinds of changes in your life for life insurance, we're looking to do things, there are some really cool techniques you can do. So ask yourself, do I need this policy? If I don't for my planning, maybe the charity can benefit from it at a later date. Another topic here is IRAs. If anyone's 72 or older, they know exactly what RMDs are, required minimum distributions. A couple years back, they made a very cool option for gifting that you're able to give up to $100,000 directly to a charity from your IRA. And in doing so, it'll count towards your RMD, right? And also as a deduction to the charity. So to do this, you'd actually call your IRA brokerage firm or the account. You'd ask them to make a distribution directly to the charity. It's called a trustee transfer. In doing that, a couple of things happen. It will reduce your adjusted gross income, which potentially would also reduce taxation on Social Security and other income sources. So talk to your CPA if it makes sense to have your RMDs, if you're over the age of 72, and have them directly paid to the charity. In doing so, you might get some additional benefits to do so. Other technique, and I'll end with this one here. If you have an IRA and you have plenty of assets or other things in play, you can leave the IRA to the charity also. Whenever a child or a non-spouse inherits an IRA, there's actually a tax being paid in addition to the estate tax. And these IRAs today have to be depleted over 5 or 10 years. So depending on the amount of the IRA, you can leave a charity directly as a primary, as a partial, and leave that IRA to the charity if you want to avoid not having your beneficiaries pay certain taxes. Again, talk to your CPA to see if this makes sense. But this is a technique we see a lot of times when there are extra funds or someone's very charitable at their passing. So with that ends my presentation. And what I really was hoping to accomplish is just kind of give everyone an idea of how some of these documents work. Hopefully striking a conversation and creating a new dialogue with you and your family and whoever you create in your board of directors personally. And if I gave one person a good idea to give a little extra money to charity or the opportunity to have a little more tax savings, I think I accomplished my job this morning. I want to really thank everyone for the opportunity to talk this morning. I hope you learned something, and I'd be happy to answer any questions. Thank you so much.
Well, thank you, Kevin, for a wonderful and informative webinar on educating us on the 5 estate planning documents that everyone should know to ensure their wishes and goals are executed when they aren't able to do so themselves, as well as covering basic charitable gifting ideas to help maximize your tax deductions and donations to an organization. We will now be taking questions from our viewers. I've been monitoring the questions that have been submitted in the Q&A. This is our first question that our viewer has submitted. How often should we have an estate planning document reviewed?
So certainly every 3 to 5 years, you want someone to review it, especially if there's life event changes in terms of marriages, divorces, and things of that nature, especially if your wishes change. So not just a marriage or divorce, but certainly if you want other things to happen. We have a client who has increased her giving because she knows her beneficiaries won't do so. She went back to her trusts and put in language for the trust that she's leaving to her family to give additional charity because she knows that her family won't give the same level she wants to. That's an important distinction. Yeah.
All right, well, thank you. Our next question, how many backups should we have for a trustee, power of attorney, and medical surrogate?
Generally, you want at least 2. If you can't go past 2, then you want at least, otherwise you may have to get a corporate trustee or someone else come into play. Those can be costly. But you want at least 2 backups. Most attorneys will ask for 3, but I say at least 2 just to get it moving. Yeah.
Great. Another question, do most people need a revocable trust or would a will be okay?
It really depends. So if you have, I mentioned in the slides, if you have the ability to name beneficiaries that avoid probate on most of your assets, then a revocable trust may not be as important. However, if you don't want to leave money directly out to somebody, a revocable trust can add some language that protects people. Lots of people will leave money to trust because they have a child who's married, maybe isn't having the best marriage, and they're concerned about divorce, or they're concerned about if they have kids who have special needs, or they have kids who are concerned about, being spendthrifts or drug and alcohol abuse. That's when trusts really come into play because you can protect money from making a left turn or being used. But if you have the ability to transfer directly to people, those aren't the concerns, you can probably get away without having one, but really consult an attorney.
Okay. Another question for you, Kevin, is if I wanted to give away appreciated stocks, how do I determine which ones?
That's a great question. So there's a couple ways to do it. Towards the end of the year, a lot of portfolio managers will actually reallocate portfolios and sell off things and for gains and for losses, trying to equal out the gains with losses to reduce taxation. So in doing that, you can talk to your portfolio manager, your advisor, and ask them if there's any stocks you'd be reducing. Any stocks will be reducing some exposure to. And in doing that, you may want to give that stock away to a charity. If you're going to sell it already, and they already want to reduce the exposure because of your planning, it's a perfect opportunity to do so. If it isn't the case and you have stocks that are appreciated, then you can just pick a stock you may have in a portfolio managing yourself. The very cool thing is you can give that stock away and you just buy it right back again. So Apple, for instance, people hold for a long time, they have some serious gains. So you can give the Apple stock away and buy it immediately. And you're still invested in the stock, but now you have a new basis. There's no tax. You've accomplished a lot of things. You've given a gift to a charity, you haven't paid capital gains, and you're still invested where you want to be invested.
Right. And our last question, how can I have my RMD paid directly to a charity? Now, if you could also help explain what an RMD is.
So an RMD is required minimum distributions. It's the required distributions that the IRS, the federal government, gives you on retirement accounts, on IRAs, 401ks. Now the age is 72. It used to be 70 and a half. So in 72, in the year you turn 72, the IRS actually has a table. They're very romantic about it. They take your life expectancy, they divide how many years we living by the value, and they say you got to pay this much. If you don't do that, they actually penalize you 50% of what you should have taken out. So it's a big hefty penalty. So because you're required to take that out anyways, a lot of people receive income that they don't really need in RMDs because it's taxable from their IRA. So in order to affect the gift, you'd actually call whoever your IRA is with, whether it's Schwab, Fidelity, whomever, you'd actually ask them to pay the charitable gift directly to the charity. They'll give you a form and they'll send a check or wire the funds directly to the charity. In doing that, you want to keep that form so you notify your CPA that you gave that RMD directly from the account, and hopefully that'll give you some additional benefits. But certainly consult with them prior to doing so. Yeah.
Great. Well, thank you. So thank you, Kevin Milgram, for an informative and educational webinar. On behalf of the Jewish Federation of Broward County, we want to thank you for providing insight and awareness on charitable gifting and estate planning techniques to help protect yourself and your family. We would like to acknowledge and thank Benefield, Lasik, and Starr for being our corporate partner. I would also extend many thanks and appreciation to our current and outgoing High Care Chair, Carol Lasik, for her time, dedication, and commitment to the High Care program. I would also like to take a moment to thank Ava Phillips for sharing with us her heartfelt testimonial about receiving services from High Care for her late husband and currently for herself. When you create a legacy of $100,000 or more to the Jewish Federation, you have the opportunity to utilize our High Care program. High Care provides and offers you an individualized care management plan, becoming your advocate when you are confronted with the challenges of aging and health-related issues, offering a peace of mind to you and your family. The High Care program is available to our legacy donors, society donors, 65 years of age and older. Please feel free to contact me, Esther Cohen, at ecohen@jewishbroward.org, or to find out how High Care can help you. Thank you again for participating in today's webinar. Please look for the information in our upcoming High Care newsletter and on the Federation website with next year's webinar schedule this fall 2021 and spring 2022. Please enjoy the rest of your day, stay safe, and have a great summer. Thank you.